In this week's episode, we sit down with veteran sports journalist Tim Sullivan to discuss transparency issues arising from his attempts to obtain documents from the University of Louisville. Those documents related to the NCAA's infractions and enforcement case following the 2017 basketball-related scandal that resulted in federal criminal prosecutions in the Southern District of New York. Louisville and its recruitment of prize basketball athlete Brian Bowen were implicated in the federal prosecutions. After the criminal cases concluded, the NCAA initiated a series of infractions and enforcement cases, including one against Louisville. The Louisville case and 5 others were adjudicated through the NCAA's independent accountability resolution process, which was implemented in 2019 following the recommendations of the NCAA's Commission on College Basketball. The IARP was designed for high-stakes infractions and enforcement cases. At the time of his public records odyssey with Louisville, Mr. Sullivan wrote for the Louisville Courier-Journal. After Louisville denied Mr. Sullivan's public records requests, the Courier-Journal filed a lawsuit under Kentucky's public records laws. Mr. Sullivan walks us through his initial public records requests, the lawsuit itself, and then important transparency themes relevant to his battle with Louisville. Mr. Sullivan has been a sports writer and columnist for over 45 years, with stints in Cincinnati, San Diego, and Louisville. He left the Courier-Journal in 2023 and now works as a freelance contributor for Leo Weekly in Louisville. Mr. Sullivan is a graduate of the University of Missouri's School of Journalism. Just a note, this episode was recorded on February 10th, 2023. Good morning, Tim, and welcome to the DYK podcast. We're so happy to have you with us today.
I'm very pleased to be here. I'm sorry for the technical difficulties.
Don't worry, I have my share of those as well. So what I just want you to do is take it from the top, the very beginning of this saga. And if you could give our listeners and our viewers some context to set the stage for your attempts to get documents and records from the University of Louisville.
Okay. It really started when the university released the notice of allegations itself that the NCAA sent to the university. And what was made public was a document that, I think on page 12, some supporting documentation that we wanted to see. We were told that those documents did not exist in a physical form that the university could provide, which was a dodge. They were accessible through a secure NCAA portal that is used, I think, in large part to circumvent public records scrutiny. So after some back and forth and some clarification from the NCAA on exactly what the portal contained, as a Courier-Journal in Louisville, lawyers decided to file suit. And that, I think, was in December of 2021. It took about 11 months between the initial case, which was resolved on May 27th, and the appeal, which was resolved on November 16th, to force the university to provide those documents, which were extremely interesting. The interviews with Rick Pitino and Chris Mack and others shed a lot of light on situations and that had not been made public previously. And most notably, Tino referred to one of his former assistants as a pathological liar, and that he had ruined his life and cost him $38 million.
Is the Courier-Journal in Louisville, is that kind of the primary local paper in Louisville?
It's really the only daily paper in Louisville.
Okay.
I think it was founded in something like 1870 and it's won a bunch of Pulitzer Prizes, but like all newspapers, is suffering contraction of resources.
So just to back up a little bit and to provide some 30,000-foot context, this case, the Louisville case, is the product of the quote-unquote basketball scandal that arose in 2017. And that scandal resulted in some criminal prosecutions in the Southern District of New York. And Louisville was one of a number of schools that was involved in. All the universities that were implicated were Adidas schools. Is that right?
That's my understanding, yes.
Yeah. And then we had these prosecutions in New York that got a lot of media coverage. And then on the backside of that, the NCAA came in and they started their own investigations. And Louisville was one of 6 schools that they really focused on. And you mentioned the notice of allegations. Could you explain to our viewers and listeners what that is and the significance of it in this investigation process?
Well, the NCAA, in the process of an investigation, formulates charges against the individual schools, and they classify them as level 1, level 2, level 3. And in this case, Louisville, which was the subject of a previous NCAA investigation over strippers in the basketball dorm, was in a slightly different position than in the other schools because it was, quote unquote, a repeat offender.
Right.
So there was quite a lot at stake as this investigation was taking place. The charges that came out of it, or the allegations, many of them were pretty minor in nature, but some of them were significant. Most of them centered, at least the first wave of the investigation, centered on the recruitment of Brian Bowen, who was a 5-star player who signed with Louisville very late in the process, and he was steered to Louisville for a variety of reasons, one of which was that there was an opening at his position where he might be able to start very quickly.
Right. And so really there were two fact patterns in the Louisville case. The first one, the Brian Bowen fact pattern, was a similar fact pattern to other cases that resulted in the Southern District of New York cases. And then we had a second fact pattern that involved the coach that replaced Pitino, because as a consequence of the investigation, the Brian Bowen component of it, Pitino lost his job. Then Louisville hired Chris Mack as the head coach. And the NCAA investigation really blossomed. So it went from the Bowen Pitino phase into the Mack Dino Gaudio phase. Could you explain that transition and then how you got involved in focusing on that second phase?
Well, I was really focused on both phases because I thought all along that the Bowen phase had the potential to have more severe penalties. The Mack Gaudio phase was kind of bizarre. They had been longtime associates and friends. They'd worked together at Xavier University. Gaudio ended up going to West Point and Wake Forest and ESPN, and ended up coming back to coaching under Mack, who he had previously coached. And at the end of the 2021 season, I think on St. Patrick's Day, Mack just told Gaudio that he was not going to bring him back. Gaudio's response was to threaten him with exposing various NCAA infractions, potential infractions. Mack recorded the exchange, and it ended up leading to a federal charge of extortion. And Gaudio ended up going to court and getting off with a fine, as I recall. But the residue of that was that Mack had said some things that were recorded that were fairly incriminating, not all of which he initially shared with the university, but which the FBI was able to find when they got access to his phone. So he ended up getting suspended. It was never really explained in detail why, but it was fairly clear that he had hidden some things from the university, that essentially where he had told Gaudio that he would pay him out of his own pocket if necessary to keep this quiet.
Yeah, there's a Jerry Springer quality to that second fact pattern. So the initial notice of allegations, which I have analogized to the equivalent of the criminal indictment. That's where the NCAA comes in. They lay out their case, and then the institution or the individuals, in this case, the head coaches and the assistant coaches, have to respond to that. As I interpreted the notice of allegations in both cases, and then the ultimate opinion of the resolution panel, the NCAA wanted to establish two things. First, they wanted to establish that the conduct of Adidas could be imputed to Louisville, because the NCAA doesn't have jurisdiction over third parties. They don't have jurisdiction over agents. They don't have jurisdiction over NIL collectives. They don't have jurisdiction over the shoe company. So what they try to do is to tie the conduct of those third parties to the institution so that they can use their enforcement and infractions powers to control them, essentially. And then the second issue that's really common to both of these fact patterns is the responsibility of the head coach. And the NCAA has a bylaw, I think it's 11.1.1.1. I think I got that right. that presumes that the head coach is responsible for everything that happens in the program. That presumption is rebuttable. And the NCAA really wanted, I think, to make an example in these basketball cases of the head coaches and try to get them essentially responsible for everything that happened beneath them. Is that an accurate characterization of the two big issues there?
Yeah, I think so. The question of whether Adidas is a quote representative of the university's athletic interests is a fascinating one, and it's
Hmm.
one that has been contested in numerous of these cases because the University of Kansas, for
Hmm.
example, and I think that
Right.
case is still pending.
Hmm.
They used the same lawyer or one of the same lawyers that Louisville did, and their script in their responses is very similar to Louisville's. The NCAA enforcement staff has argued that there is specific language in the bylaws that establishes that a shoe company or any company that has those kind of ties to university can be considered a quote unquote booster. Both Louisville, Kansas, and others have contested that, and they were successful ultimately. At least Louisville was with the IARP panel in making that case. The other bylaw that you referenced was the one about head coach's responsibility, and the presumption of responsibility differs, I think, to a large extent with the actual practice, which is that if a coach can keep his eyes closed and cover his ears, he has a pretty good chance of surviving no matter what his assistants have done. I think that proving that a head coach had knowledge or complicity in the event of infractions can be very difficult, and most coaches are smart enough to insulate themselves from whatever their assistants are doing. And that's been a longstanding practice that the assistant coaches take the fall.
When you were looking at these cases, in terms of newsworthiness and the effort that you were going to put into pursuing this, how are you viewing them, and what influenced your decision to serve the public records request and then to keep pursuing it when you got some very interesting responses from Louisville?
Well, I think that in this city, there is no professional football or Major League Baseball or NBA. The
Hmm.
University of Louisville is our pro team, and it's of tremendous local interest and to some extent national interest. Rick Pitino is a Hall of Fame coach, has won national championships at Kentucky and Louisville. That one was later vacated. He's been to the Final Four with schools, and anything that pertains to his career is of keen interest in this town, even now that he's
Hmm.
coaching at Iona. That said, I just read the notice of allegations and I saw this reference to additional exhibits. And I thought, well, I want to know what's in there. And eventually I was provided a list, itemized list of what the exhibits were without any additional information as to the contents of specific things. And I saw interviews with Rick Pitino, with Chris
Hmm.
Mack, with assistant coaches. And I said, this is important stuff. I want to know what the NCAA knew when it made these allegations and what these coaches had said about it, because they had pretty consistently said, I can't talk about this while the case is ongoing. Well,
Right.
they had talked about it in their interviews, and
Yes,
they had
yeah.
talked pretty candidly, as it turned out.
I want to come back to the actual process of you using public records laws to try to get this information. And you had to utilize public records laws just to get the notice of allegations. That was the first thing that you asked for and the first thing that you got. Is that right?
I think the notice of allegations was provided by the university without a public record request, although we may have filed it in recognizing that it was coming due and wanting to get it as soon as possible, knowing that it was a competitive document. The university has been fairly good about providing key documents as they come along, but they were determined to shield the additional exhibits
Right.
for reasons that have never been adequately explained.
Yeah, that's interesting. And a lot of people who haven't been deep in the weeds in the documents that are the product of the NCAA's infractions and enforcement process may not appreciate just how complicated they are. There are tons of documents. And in the notice of allegations, which is a general statement of charges against the school and the coach or the athlete, whoever is being investigated, you have evidence and information that's really summarized, and then you will have it referred to or described, but not made available. So you really can't read a notice of allegations without having the underlying supporting information. It just doesn't make sense.
Well, it makes sense only in terms of this is the indictment, but it's not all the information. It's you don't know what mitigating are made, what admissions may have been made that are not included in that. I certainly think the primary thing I was interested in was reading the transcripts from Rick Dino and Chris Mack, but I ultimately got 16 transcripts of various people, some of whom were only peripherally connected or were not central to the case, I should say.
Right. But that was after a year of litigation, right? That was the end product. So you served your first public records request October 21st of 2021, and you were focusing on the reference to these additional documents that was in the notice of allegations. From that point, explain to us, not necessarily communication by communication, but request by request, what you were asking for and what response you got from the University of Louisville.
Well, I was seeking basically the same documents over and over again. And initially, I was told that the documents were not in the quote possession of the university, which was a dodge. And eventually went to the NCAA and said, it's my understanding that there's a secure portal that the university can access where these documents exist. And they confirmed that. And then I went back to the university and said, well, this is what they told me. Please, I'd like to make an appointment to view this portal within the next 7 days. And they continued to claim that the documents were, quote, preliminary, which would be shielded from open records law. The courts ultimately found that was not a valid excuse.
So first it was, we're not in possession. Then they invoked FERPA, the federal student records law, saying that these documents were protected by FERPA. And then they also made the argument that these documents were part of a preliminary investigation that fell within an exception to Kentucky's public records law. So you had 4 or 5 different justifications. They kept coming up with a new justification for not providing you the documents before you actually decide to file a lawsuit. Could you talk a little bit about those objections and how you viewed them?
Well, I've had a long history of public records with the university, and their instinct is to say no whenever they can, particularly with sensitive matters that might be embarrassing. But in this case, it was fairly clear to me that these documents existed, that they were referenced in this notice of allegations, and that they were pertinent. Right. As the excuses piled up and my frustration rose, I started speaking to our editors and saying, I think this is something that is important and that we should pursue in court. And the Courier-Journal's lead attorney, John Fleischaker, essentially wrote most of the public record law in Kentucky. So he was coming at it from a very strong position of expertise. And he was easily persuaded that this was worth pursuing. And decision to file suit, that has to be made by the editors, not by the reporters. But they went along with it, and I'm very glad they did.
And under Kentucky's public records laws, once a proper request has been made, the state institution or entity has 5 days to respond. Is that right?
5 business days, I believe.
Right. And interestingly, the public institution has the burden of proving that the records are not public records. That suggests to me a public policy of disclosure and openness.
Well, Presumably, there's also a cost benefit analysis, I think, that goes into these things. And the university ended up spending tremendous amount of money defending this case. And I'm talking about the NCAA case, not the Courier-Journal case.
Right.
And their lead attorney or their litigator, Neil Katyal, was being paid $2,465 an hour. So the money that they ended up spending to delay the disclosure of these documents was a pittance compared to what they spent on their defense. And I think they probably felt, and I'm speculating here, that withholding these documents, which contained some embarrassing information, was in their interest, and that they would run the risk that they would be found willfully violating the law and fined, because that was a small change compared to all that was at stake in the NCAA case.
So you wind up filing a lawsuit, and then the university responds and recycles all of the arguments that they made before you filed suit that justified their refusal to provide the records. Then the paper, the Courier-Journal, files a motion for summary judgment saying we win. This is a clear-cut case. And then we get a ruling from the judge, which is in, May 27th of 2022. When you got that opinion and read through it, could you talk a little bit about your interpretation of how the judge handled all these excuses that Louisville made?
I think that the judge was pretty emphatic that there was no justification for the universities withholding these documents. When you accuse a public university of willfully violating the law, I think that's a pretty strong condemnation. I think she picked the arguments apart, and I'm not an attorney. I won't try to parse the language, but I think that it was pretty clear to me that she wasn't buying any of it, and that the exhibits were produced by a third party that was non-governmental. The university claimed that they were preliminary, I think was really a reach, that they were interviews that contributed to the allegations which had been published. They were background information. They explained things that were not in the notice of allegations. And the FERPA argument really didn't apply. I mean, some of the materials that I eventually got were redacted to eliminate students' names, and those weren't my main interest. My main interest was what Dino said and what he said about his assistant, what he said about the case, without specifically mentioning Brian Bowen. Right. I think the university created a pretense essentially as a stalling tactic to try to withhold these documents as long as they could. And they ultimately succeeded in that, because the final decision by the judge on November 16th followed the IARP ruling by 2 weeks. So they accomplished their aim. They spent a certain amount of money to do it. I don't have a total, but I'm guessing it was maybe $100,000 or less.
You're talking now about the public records litigation?
Yes.
Yeah.
Yes.
Okay.
Oh, I mean, the other litigation is far more expensive.
Millions and millions. Yeah.
Yeah. When you consider all the ripples, what this long running investigation had done to recruiting, attendance, fan support in general, I mean, this is a huge case for the university and for the city. I mean, there are businesses downtown that have really struggled because attendance at basketball is down. The ripples are many, and that's why this was such an important story.
Right. And the program's really struggling right now. I mean, I don't think there's any question about that. But this opinion, basically, the judge slammed the University of Louisville and just said, look, these excuses just barely passed the blush test. And this was a pretty strong order, but the university wasn't done yet, were they?
No, well, they decided to file an appeal, and I was extremely frustrated by the delay, because I knew the clock was ticking and that eventually the IRP was going to rule, and that was going to take the edge off of anything that we would be able to learn from the documents. The length of time between the appeal and the final decision was tremendously aggravating.
Yeah. So after the judge ruled in May, the university came in and filed what's called a motion to alter, amend, or vacate the judgment. And they based that really around the central argument that this investigation was still preliminary, and the judge rejected that. And then we're into the fall of 2022. And then on November 3rd of 2022, we get the final decision from the adjudication panel with the IARP, the final say in the NCAA's investigation on what happened with Louisville. If you could talk a little bit about that decision.
Well, the IARP decision was almost a complete victory for the university. Most of the charges were dismissed or minimized, and Rick Pitino was exonerated. The potential of postseason ban which terrified people. In fact, there were fairly prominent journalists who suggested that if ever the NCAA was going to invoke the death penalty again, that Louisville would be a prime candidate. So there were significant concerns about what the penalties were going to be. And it turned out that it was barely a wrist slap. So all the money that the university spent on its defense and all of the delaying tactics it implemented in the document search ultimately was a victory for them. And I think they viewed it as a cost of doing business and didn't see themselves as violating the law so much as protecting their interests. But again, that's my read on it. And I'm certainly not unbiased in this case, because I felt to a large extent I was victimized by their delays, and that the story that I ultimately wrote was for a weekly publication here in town, and was, I'm told, the most read story during the tenure of the editor of that publication. So I can't help but wonder what the impact would have been if I'd written it for a more mainstream newspaper like the Courier-Journal. But that's a personal gripe, and it really doesn't pertain to your question.
Yeah, it does pertain to my question in terms of the effectiveness of Louisville's response to your public records request. Because if there had been a more forthcoming approach, and some of the information that you wound up getting after the IARP decision was issued, if that had been in the public record beforehand, the entire discussion about this case could have been different. And so on those two key issues of the shoe company responsibility and then head coach responsibility, the IARP said that there was no evidence that Adidas was acting as an agent of Louisville, essentially, in moving money to Brian Bowen. That was the allegation, at least. And then they also said that Rick Pitino and then Chris Mack as well, in both of those fact scenarios, they were not responsible for what the assistant coaches did beneath them, because they promoted an atmosphere of compliance. And when you read that opinion, how did you respond to those conclusions? How did you take that in?
I think that one of the reasons that schools such as Louisville sought the IARP process was the sense that they might get a more favorable hearing than one that was done by NCAA officials, university representatives. They thought that legally, and most of the people on the IARP panel are detached and have strong legal backgrounds, that they might view it differently because the standard of evidence would be different than it might be if you went through the normal NCAA process. And that's exactly what happened. I think that as much as people wanted to say or wanted to believe that Rick Pitino should have known, that he that all this couldn't have happened on his watch without his knowledge, finding the smoking gun was much more difficult. And there's still a standard of proof, I think, in the legal system. And I think the IARP looked at the report of the enforcement staff and said, you're kind of adding 2 and 2 and getting 5. That yes, there were violations committed here by assistant coaches, and those assistant coaches were punished, but there wasn't something that connected Pitino directly to it, or in some cases, Chris Mack, although that was a slightly different situation in that most of the violations were acknowledged, but there was some question about their severity, and the university challenged whether these were really serious violations or trivial. And
they were trivial. They involved unauthorized practice sessions and then some recruiting issues on some material that was really meaningless. So there wasn't much there. There wasn't, and as it turns out, there wasn't much there with the Bowen Patino fact scenario on the backside of the IARP's decision. And during that press conference after the decision was released, in response to a question, I can't remember exactly what the question was, but the head of that panel, David Banke, he talked about the amount of work that the IARP put into that Louisville case. And he was saying that there were thousands and thousands of man hours of work. And we don't know what the cost to the system is of that kind of prosecution. But when you got a peek into how the sausage was made in infractions and enforcement, did you ask yourself, was this really worth it? And how much money was actually spent?
Well, getting back to what you said earlier about the trivial allegations related to the Chris Mack's tenure, I thought all along that they were pretty petty, but in the context of a school that was on probation and that was already under investigation, it was a level of sloppiness that put them at risk of being viewed as a scofflaw. And they were, I think, fortunate that the climate had changed in college athletics, that with NIL, the transfer portal, that things that would have been seen as egregious violations a generation ago are now legal. The NCAA is going to have a lot of difficulty trying to regain some control of the system where recruits and athletes can make 6 or even 7 figures as college athletes. And in that context, I think that the long delay in this case that had spanned over 5 years between the Southern District of New York press conference and the resolution of the Louisville case worked to the university's advantage. It was a tremendous cloud over the program. It hurt it in many ways, but in terms of the final decision, I think things had evolved to a point where it seemed almost silly to enforce rules that were no longer relevant.
Right. And I think that's what some of these questions in the press conference went to. But, as you know, and as Mr. Benke explained, the infractions panels and the adjudicators have to look at the rules that were in place at the time that the violations were alleged to have occurred. And to me, the absurdity of that from a value standpoint was obvious. And so much had happened. You had the Austin case, which was on the books before this Louisville case was adjudicated. And that was a substantial body blow to the NCAA's conceptualization of amateurism. And then the post-NIL environment, where that $100,000 payment or whatever amount actually made it to Bowen's family, that would be entirely appropriate if it were called NIL compensation. And a lot of people would be asking, why the hell did you settle for $100,000? And that's the environment in which this opinion was released. And then you look at how much money went into it, and you just have to ask yourself, what are we doing here? This makes no sense at all. Do you think that the debate has moved to a point where we can talk about the NCAA's regulatory authority on those terms?
Well, I think you make a great point. The debate over amateurism really seemed to shift, at least in my view, over the last 10, 15 years, where the average people were looking at the money that was being generated and saying, why are the athletes denied a cut of this when coaches are making multi-million-dollar salaries? And I started in journalism in the late 70s, the idea that a college coach could make as much as a CEO of a Fortune 500 company was outlandish, but the revenues have risen so much that preserving amateurism became more and more cynical, I think, by the universities, by the NCAA. And it was public opinion shifted, and as resistance to the idea of college athletes getting paid eroded, I think this case was a pretty good indicator of how far we've moved in a pretty short period of time as a society and as a culture and college athletics in general. The costs of this at the end of the day seem ridiculous, considering how little penalties were imposed and how what what once was forbidden is now commonplace.
So, Tim, when you got into the documents, when you finally got to peek inside and you saw the extent of the investigation, were you surprised by how big it was, how much information there was, how many resources were being thrown at this investigation?
No, not really. I knew that many people had been interviewed, and
Mhm.
I looked at the long list of exhibits, which included all kinds of records, financial records, NCAA compliance records, et cetera. And there were a lot of billable hours in that document, and I wouldn't be able to begin to guess at the ultimate cost, both to the NCAA and to the member institutions that were under investigation. I mean, I think you alluded to 6 schools that were really the focus of this, and if you multiply what U of L spent times what Arizona spent, what
Right.
LSU spent, et cetera, I mean, you're getting into millions and millions of dollars, and the effect of this long-standing investigation, just having it unresolved, was many more millions of dollars.
That's right.
And the impact, if you were a 5-star player, basketball player coming out of high school, why in the world would you go to the University of Louisville during this period with this uncertainty hanging over it, whether they were going to be allowed in the tournament or not? And I think for the university, it's very possible that the final cost could run to $100 million.
Right.
This was once the most profitable program in college basketball, and not long ago. But as you know, the basketball team is 3-20 or 3-21, and and looking at a pretty long rebuilding process.
But you talk about the cost. I would throw in to that calculation the amount of money that was spent in these prosecutions, in the Southern District of New York. The total cost to the system, to the institutions, to the people involved is almost impossible to calculate, both in hard numbers and then the reputational interests. And for the athletes, the lost eligibility, their lost careers. And I look at all that and I say, for what? What was the underlying value here? What were we fighting for? And I was listening to that press conference, and I'm listening to an obviously bright, well credentialed person speaking to defend the system. I just thought, we've lost our way.
I think throughout the process, and particularly at the end, I circle back to the ongoing, or what now seems passe, but long-standing argument about amateurism and all the rules that existed to try to protect a system that denies to college athletes the rights that are available to virtually every other American,
Yeah.
to seek their value in a free market. I know of no other place where a talented individual is denied the ability to reap the rewards of that talent for reasons of, quote, competitive balance. And I think that by the time that this case was ultimately resolved, a lot of the resistance to paying athletes had evaporated, and schools were scrambling to try to be competitive on the NIL front. And I felt a little for Brian Bowen and how he had been derailed from his college career by rules that were antiquated and increasingly irrelevant. And this is a player who definitely could have benefited from playing in college, who has bounced around on the fringes of pro basketball, and as far as I know, is not currently employed. And there are many other athletes who have, I think, been made to feel like criminals for accepting a small portion of what they're worth. The revenues that major schools generate from March Madness, from college basketball and football in general, are enormous. And to think that everyone deserves a cut of it except the people who are putting their bodies on the line is absurd to me.
Yeah, I couldn't agree more. You said that really well. And to add to that, there's also a racial overlay to the absurdity of this business model, particularly in basketball, big time men's basketball, where you have a labor force that is overwhelmingly African American. And when you look at who winds up paying the price in these ridiculous infractions and enforcement cases that are really kind of show trials for the NCAA to display its amateur virtue to the outside world, you really see that it's the African American men in that system that are in the crosshairs. And I think we're not talking honestly about the racial component of the inequities in this system and the failure to recognize these athletes and these coaches' rights as Americans.
I would agree. And I think that if you look at most of these cases, the lead assistant who has been implicated is generally African American, and the head coaches are almost exclusively Caucasian. And it does raise a lot of concerns about the equity of justice in the NCAA system. And I think that's why the head coach responsibility rule was first enacted, because of the sense that the head coaches were skating and the assistants were being made to be scapegoats for a system that was nudge, nudge, wink, wink. We're going to do what we can to track these elite athletes. And the head coach either doesn't want to know or wants to be insulated from it to such an extent that it doesn't come back to bite him. We've seen example after example of that. And I think that contributes to the general cynicism about the system.
Right. I guess I want to close this out, Tim. We're focusing on transparency with our project in DYK, and we're talking to a bunch of different people and different pieces of the transparency puzzle. This is really in the nature of a case study, a lack of transparency and the behavior of institutions in response to legal requests for information. So, on the backside of your experience with the University of Louisville, how do you view the culture and climate of big time athletics departments in terms of transparency and cultures of silence?
I think that universities should answer to a higher calling than expediency. And too often they shield embarrassing information that should be public record almost as a reflex. And these are human beings, and they're not saints, and they have interests to protect. And if you're a subordinate functionary of a university and you get a request for something that is going to put your superiors in an awkward position, you're likely to think twice before releasing that. But universities talk a lot about transparency, but they don't always follow it. And it's up to reporters and public spirited individuals to press them on these things. And there was a case earlier from the previous Louisville investigation in which a local doctor challenged the university on information it had when it made the decision to self-impose a postseason ban. And he got a very similar runaround to what I did. And hats off to him for making the effort to try to unearth the information that would still be valuable. But he didn't have the resources of the Courier-Journal lawyers, and he had other things to do. I mean, this was not his full-time job. I admire Dr. Hasselbecker for persisting there, and I'd like to think that the victory that the Courier-Journal ultimately won was in some part attributable to the efforts that he made in the previous case.
And it's going to take that kind of courage going forward to hold institutions accountable. Universities simply don't want to be transparent, and that's a problem. Do you think that's an issue that kind of transcends college sports and really goes to the climate and culture of big time universities now and their concern about reputational interests and marketing and branding and all that stuff?
Well, sure. And I think there's even a more recent example on the University of Louisville when Vince Tyree, who was the athletic director, was being courted for other jobs and ultimately resigned. There was a board of trustees meeting at which his status was being discussed, and they tried to go into executive session to talk about this out of view of cameras and media. And I stood up and said, your own requirement is that this has to be about hiring, firing, or some other exception. And you're not hiring him, you're not firing him. Why are you claiming this executive session? They never explained why they did it, but they did it anyway. And my protest was fruitless, but at least we put them on notice that you can't act with impunity when it comes to information that is important to the public and should be public information.
Well, Tim, I'm so happy that you stuck with it. Without the persistence that you had on this story and then the Courier-Journal's willingness to move forward with it, we wouldn't be having this conversation. And transparency is just so important. And do you have any, you're a veteran journalist, you've been in the business for a long, long time. What would you say to a young journalist coming in who may be a little less cynical of institutional interests than the veterans might be?
Well, I think you have to ask yourself, in a situation like this, is this something the public is entitled to know? And does the law of your state allow you to proceed on this, if only for your own curiosity? It doesn't have to be that you have a moral eagerness to pursue something. Sometimes it's just something I want to know what went on here. And curiosity, I think, is the central virtue of journalists. Is you want to know how the sausage was made, and sometimes it's not pretty, but it didn't take any courage to pursue this. It took a commitment from the Courier-Journal to have its lawyers go after records that we thought were public. And I would hope that in other markets where you're getting stonewalled by universities or public institutions, that they see this as a precedent and an opportunity to push harder to get information to the public. I mean, it doesn't really matter to me personally whether I get these transcripts. It's not going to change my quality of life, but it does add to the dialogue and the understanding of the issues that arose in this case, and in a case that has cost the university, the taxpayers, local businesses, untold millions of dollars. So to the extent that we shed a little additional light on it, I'm happy, and I would hope that other reporters see this as something they can use to push harder on public records.
Great. Well, Tim, thank you so much for joining us. And I really appreciate your thoughts on this.
Thank you, sir. Appreciate you having me.
Okay, sure. Have a great day.